Judge, we have 670, I think, federal district court judges, and some believe that they have the right to enjoin an act of Congress for the entire 3.5 million square miles in the United States, even if the other 669 federal district judges disagree with them. What's the legal basis for that?
There are injunctions that courts can issue that can apply to nationwide in certain circumstances, but you've identified, I think, what is a big concern that's now being, I think, litigated in the court system, where whether or not one judge, when it comes to an act of Congress, in trademark cases and other cases, we issue injunctions that apply, obviously, across the nation, but when we're talking about an act of Congress, I understand the concern that one judge could stop.
What's the legal basis for it, Judge?
Well, the legal basis would be that the judge is trying to enforce a constitutional provision, and it could be applying, obviously, across state lines at multiple points. So, but okay. I understand the concern, and it also raises the issue of judge shopping, too. If you have nationwide injunctions, litigants can try to find one district judge in the nation.
I get it. Sorry to interrupt you.
That's okay.
We just have 5 minutes.
Sure.
Professor Park, you practice right now, don't you?
Yes, Senator.
I've read your resume. My guess is you charge at least $50 an hour.
It's a little bit more than that, but yes.
Okay, 60. Have you ever had a client come to you and say, I'm going to pay your hourly rate to represent me in this lawsuit, and I don't care what position you take. You can even agree with the other side if you want to, and I'll pay your bills. Have you ever had that experience?
I have not had that experience.
I haven't had that experience either. You have to take the position of your clients, what's best for your client, right?
Yes, sir.
In fact, if you don't do that, you violate the canon of ethics, don't you?
Yes.
And you get thrown out of the bar.
Yes, sir.
Okay. Have you agreed with every position your client has ever told you to take?
No, I have not.
Have you liked every one of your clients?
I shouldn't say with specificity, but it has varied.
Yeah. Some universities contend that they know how to discriminate on the basis of race in college admissions the right way, in a way that is morally sound. How do you do that under the United States Constitution?
Well, Senator, the framework that the Supreme Court has set forth is strict scrutiny.
But give me an example. I understand strict scrutiny and all that, but how do you do that if I'm an admissions officer and I say I'm going to pick a race, and on the basis of race, let fewer students of that race or religion into my university because I know how to discriminate in the right way? Give me a real-life example of how you can do that and still be moral about it.
Well, what I can say to that, Senator, is that the Supreme Court has offered guidance about giving serious good faith consideration to the use of race-neutral alternatives. In other words, if you don't have to look at an applicant's race, but you can achieve the educational benefits of diversity without doing that, then you should do it.
Well, what if you use this race-neutral criterion and it ends up having a huge racial impact? So you've got de facto discrimination. Should that matter?
Well, the use of race-neutral alternatives is one consideration that universities can take into account in figuring out how to achieve their educational goals.
But let's suppose, I know I've got 4 seconds, let's suppose you adopt this race-neutral criterion and you apply it, I'm going to put my blinders on and I'm not going to consider race, and you don't, no Jewish people and no Asian Americans get into your university. Should that be a factor into deciding whether it's really race neutral?
Well, I think the Supreme Court has said that the universities can consider race as long as it satisfies strict scrutiny.
Right.
So, and I think the cases in the Supreme Court precedent from Michigan and from Texas offer some guidance into things that universities can and can't do.
I'm anxious to see, maybe the Supreme Court will give us some guidance about how you discriminate on the basis of race in the right way. Because that's above my pay grade. I can't figure that one out. Thank you, Mr. Chairman. I think if you read U.S. Supreme Court jurisprudence today, a fair-minded person could conclude that all members of the U.S. Supreme Court are now originalists. And by an originalist, I mean an approach that asks a simple question: what did ordinary citizens in the United States believe the Constitution, to take an example, believe the Constitution meant at the time it was ratified and in effect? Some will disagree with that statement, but if you look at the Heller opinion, I think it's clear the two competing issues, or two competing justices, were both taking an originalist approach. Here's my question. Let's suppose in a moment of candor, the United States Supreme Court, in interpreting a provision in the Constitution, all members looked at it and said, you know, we've looked at all primary and secondary sources, and we can't say with any sort of certainty what people would have thought the Constitution meant about this particular issue at that particular time. You with me so far? If the Supreme Court did that, who gets to decide? Professor?
Senator Kennedy, given your hypothetical, the question is who gets to decide if all primary and secondary sources have been exhausted.
If the justices in all candor say, look, we've looked at this, we've read all the secondary and primary sources, and we don't know what the average American would have believed that provision to say at the time that it was drafted or approved.
Senator Kennedy, in my heart, I believe that at that point the Constitution decides. And I think that the judges follow the law, follow the Constitution, and come to a decision. You know, one of the things that's interesting, you mentioned originalism, and there's also textualism. There's the living constitutional things. There are books that are out there that are fascinating reads. No matter what a person believes about the constitutional philosophies or the search for a cosmic constitutional theory, as Judge Wilkinson has written, is that they fall apart at the margins. And it's just very difficult to answer questions like that. I would like to think the Constitution decides.
Okay. Suppose the Constitution is unclear. Mr. Liberti?
So, Senator Kennedy, what I would do, and perhaps we'd have to move on, but I would look to the text of the Constitution first. Okay. If it's not clear how the issue should be decided under the Constitution, then it's important to look at what, at the time that particular provision was enacted.
Yeah, but what if the justices have said, we don't know, we're being honest? It could have meant a multitude of things to the average American.
Then Senator Kennedy, what?
Let me ask you what you think about this. How about letting Congress decide?
In fact, Senator Kennedy, I was about to say that I think at that point, then the court should look to see if there's a statutory basis to render a decision. If there is, because if there is a statutory basis, then Congress can return and either amend the statute, hold hearings, make factual determinations, and proceed accordingly. I think that would be the appropriate way. I would also add that the court may want to look at applying the most narrow holding
Yeah.
that it could.
Plus, we can be voted out. We get it wrong. Justice.
Senator, I agree that it's completely appropriate for the United States Supreme Court or for a state Supreme Court to point out an issue to the legislative body and invite them to address it. In fact, we have done that on occasion in the Louisiana Supreme Court, because ultimately it would be the role of the legislative body to remedy the error or the lack of clarity that you're describing.
Judge, we're going to miss you on the Supreme Court in Louisiana. We've got a great Supreme Court. You've made it stronger.
Well, thank you very much. I appreciate it, and I have enjoyed every moment of it.
I know you have. Thank you, Mr. Chairman.